Good day. This specific video will look at common purpose and rape in South Africa. And over the last 5 years, there has been a major development at the Constitutional Court, which was groundbreaking. And this is the current situation that we have in South Africa. The previous videos dealt with common purpose in terms of general consequence crimes like murder and robbery, whereas this specific video will look at common purpose and rape only. It is quite a controversial area of the criminal law, and the position in South Africa currently will not be applicable necessarily in many other countries. So the basic premise is that one would think is that if you penetrate an individual, you could be found guilty of rape, you could be charged, and the state will have to prove that you forced yourself on the person and that you raped the person, and then you'll be found guilty of rape. The situation becomes a bit more complicated when there's more than one person involved, which one can call a gang rape. This is, of course, a severely traumatic ordeal for the complainant. But it becomes complicated when you have individuals in that group who doesn't penetrate, who only stands at the entrance of a door to be a lookout. Defense attorneys over the years have raised that defense called the instrumentality defense, stating that because the accused did not penetrate the complainant, the accused cannot be found guilty of rape. And as the former rape definition in South Africa, the common law definition of rape in South Africa prior to the Sexual Offences and Related Matters Act in 2007 was a very gendered definition where you saw that only males were able to rape females. So it was the penetration of the penis into the vagina of a female. Now, after 2007 and also after the Masia case, the Constitutional Court was very clear that we need a gender-neutral definition, but they did leave it up to the legislator. And in 2007, we then had the Sexual and Offences Related Matters Act that provided a new gender-neutral definition of rape. But there were still cases and there were still some courts in South Africa who were not always clear as to how they analyzed and looked at cases where there were certain individuals who did not penetrate and only stood by and watched when an individual was raped. So there was inconsistencies at our highest courts in terms of the application of the doctrine of common purpose in rape cases. So it was important for our Constitutional Court to eventually decide on this. What we did see in the early 2010s was the case of Petu versus the state. And this case originated from a case in the early 2000s where we had, or late 90s in fact, where we had a terrible rape and various other crimes were committed in the Tembisa settlement in Johannesburg, where 8 individuals went onto a rampage and they ransacked houses and they raped several individuals. They would also be very strategic in the way that what they were doing. They would put blankets over the heads of individuals who were in the houses there, so that they couldn't be identified. So they were very strategic in the way they were doing it. So they, according to the court at the time when they were when they were charged and eventually brought to court and prosecuted, the court stated that there was prior agreement between the 8 individuals before they went to the settlement and started their rampage and assaulting and raping certain individuals. After the case, all 8 individuals were found guilty of rape. So many individuals, maybe 3 or so, did not penetrate. So even at that time, in late 90s, the doctrine of common purpose was already in place, and the courts were already applying it to rape. It was just inconsistent. And so when you read the judgments on common purpose and rape, you'll see inconsistencies in terms of courts sometimes allowing the defense to raise the instrumentality defense, meaning that as the accused, I did not penetrate the complainant and therefore I shouldn't be found guilty of rape. But in this specific case, this is actually what happened then. So in the Petu appeal, so Petu is one of those 8 individuals that was involved in the rapes in the late 1990s in Tembisa. So what then happens is he appeals to the Supreme Court of Appeal in South Africa, and first the High Court and then Supreme Court of Appeal, High Court full bench and Supreme Court of Appeal, and then the Supreme Court of Appeal does acquit him of rape, and they do accept the defense raised by the defense team that there wasn't sufficient evidence to prove that firstly there was prior agreement, and secondly the court then applies the 5 factors that was explained and included in State versus Megadesi to look at the requirements to prove that there is an active association among individuals who commit common purpose crimes. And they determined that because Petu was not necessarily always present or aware of the rapes being committed, he could then not be found guilty of rape in terms of the common purpose doctrine. So he's then acquitted. What then happens is a year after this, Tsabalala and Tuli, 2 individuals who were also at the scene in Tembisa in the late 1990s, also want to approach the court because they were in similar positions where they did not penetrate. So there wasn't evidence to prove that they penetrated in the complainants on the day. It's firstly Tsabalala who goes to the High Court and he petitions, and he's then able to go straight to the Constitutional Court because this is a matter dealing with the development of common law in terms of section 39(2) of the Constitution, which states that courts should develop common law. He goes to the Constitutional Court, and Ntuli, one of the other accused, is also able to ask permission from the court to bring his case on appeal and to be heard by the Constitutional Court. And the Constitutional Court writes a really good judgment. And again, I would advise you to read this judgment. It's not very long. It's about it's only 36 pages, and it really is not only a very good judgment in terms of common purpose and rape in South Africa, but also a damning indictment of the scourge, the problem of rape in South Africa. So the judges do not hold back, the justices do not hold back when they talk about the problem of rape in South Africa, and that it's a culture in South Africa, and that it's really a massive problem in South Africa. What the court states is that, I'm not going into too much detail into the judgment, but they state that there was prior agreement between the individuals. Because of it was really well planned, because of the fact that they put blankets over the heads of certain individuals when they entered houses, maybe some of the males, they put blankets over their heads so that they couldn't see them when they entered, couldn't see their faces. they also had lookouts. They also had people like Tshabalala and Ntuli, for example, who were standing at the doors to be lookouts, to check if there is anybody going to come, if there's any police officers approaching the houses where they raped the complainants. So it was a very well planned conduct by the group. So the court establishes that there is prior agreement. So in that case, they do not look at the 5 requirements included in State versus Megadesi to prove that there was actually active association. So they don't look at that. What they then also decide is that there is no room or scope for the instrumentality argument or defense in terms of common purpose and rape. If they argue that, and the court holds that if the instrumentality argument is not applicable in murder and rape case, murder and robbery cases, etc., why should it be a defense in rape cases? Why should certain individuals who partake in gang rape, why should they be excluded from criminal accountability? Why should they not be prosecuted if they were part of the common purpose, the common design of the crime of rape, which Tshabalala and Ntuli, and in fact Petu also was involved in? What's also interesting is that the court doesn't deal with the Petu case in much detail because the state never appealed the Petu decision of the Supreme Court of Appeal. They could have appealed it and it would have then gone to the Constitutional Court in the early 2010s, but they just didn't. And so the Constitutional Court, they stated in the judgment of Tshabalala and Ntuli versus the state, a 2019 Constitutional Court judgment, by the way, they state that the state, they declared that the state never cross-appealed the Petu versus state case, where it was decided that Petu could indeed raise the defense of instrumentality, the instrumentality argument defense, which is quite a pity. But at the end of the day, Petu was able to not be found guilty of rape, even though he was part, it seems, and that's what the Constitutional Court decided, it seems that he indeed was part of a common design, of a common purpose to commit rape on that night in Tembisa. Be that as it may, we have then the court looking at the case of Tshabalala and Ntuli to determine whether they should be found guilty of rape. And they decide that indeed they should, the convictions should stand and they shouldn't be acquitted of rape, because that they give various reasons, but one of the most important ones is that the court decides or explains that rape is a scourge in our country. It's a huge problem, and the law shouldn't allow individuals who form part of a gang rape to be exempted from accountability, so that the impunity can surface here. That shouldn't be the case. So the court states that it's very important for each and every individual who is involved in a common purpose plan of rape to be held accountable for that specific conduct. This is now different when 2 individuals walk in the street, 2 accused persons walk in the street, they see a woman and one starts to penetrate her and the other one runs away. That will be different, because then we have to look at active association form of common purpose, and then the state will have to prove that the accused number 2 who ran away was in fact aware and present that such a rape will take place, which in fact they will not be able to prove it, because he can then surely raise the defense of the instrumentality argument defense. The fact that he was not even at the scene, he wasn't penetrating the complainant, and he actually ran away. It's different to when you plan such a crime or gang rape, and 15 minutes into the gang rape, you decide to run away. That will not be a defense. And that also ties up to the defenses of dissociation and withdrawal in common purpose crimes. You won't be able to raise that defense if there's an agreement to commit such a crime, if there's a prior agreement. It's different to when it's active association and you can prove that you withdrew within a certain amount of time, and which is reasonable. But that's up for a court to decide on a case-by-case basis. And in the end of the day, it's a brilliant judgment. And what written by acting Judge Matopo at the time, and then Judge Kampepe also writes a very good obiter dictum, just a comment in the middle of the judgment, where she talks about being a victim of rape in South Africa, being a victim where a woman would walk past someone in a suit, for example, and won't even know that person is a rapist, for example, in our country. So you can't always tell that someone is a rapist in our country, but in any country. But in South Africa, the level the situation is so bad that there are so many sexual offenders in our country walking past us, and we don't even know that that person is on his way to rape someone else. So its situation is very dire. And for example, the court states here that we share stories and coffee with them. We jog with them. We work with them. They are ordinary people who lead normal lives. Terming rapists as monsters and degenerates tends to normalize the incidents of rape committed by men who know, because they are not monsters, they are rational and well-respected men in the community. Of course, these men, they abuse their power. They abuse their authority. They would make as if they are good citizens in the community, but back at the ranch, they are committing serious crimes, sexual offenses crimes. So a fantastic written judgment by the Constitutional Court, and of course a very sobering judgment, and a really an indictment on the situation of sexual offenses in South Africa. So that is the Tshabalala and Ntuli Constitutional Court case, which in the end of the day decides that when we talk about rape and when we talk about gang rape, all the individuals that are involved in that gang rape, even though one of the individuals may not penetrate specifically the complainant, may not even touch the complainant, that individual can also be found guilty of rape. So it's a very important decision handed down by the Constitutional Court of South Africa, and one that's really important to understand, that any person involved in a group rape, a gang rape, will be held accountable for rape if that person is part of the prior agreement of that rape, or if that person is on the scene and is not withdrawing from that situation and is also supporting what is happening. That individual will also be held accountable for rape and will be prosecuted and convicted. That is the common purpose and rape video, which I thought would be an important part of this series on common purpose, and I hope it will help you to better understand this very important part of our law. Thank you.